Court calls case number 19CV484, Colborn versus Netflix. Appearances, please, starting with plaintiff.
George Burnett and Michael Griesbach on behalf of the plaintiff.
Lita Walker of Ballard Spahr on behalf of defendant Netflix.
James Friedman of Godfrey and Kahn on behalf of all defendants.
And Kevin Vick of Dassey, Vick, Carolyn on behalf of defendants Laura You Charee, Moira Demos, and Chrome Media.
So good afternoon, counsel. We're here for a motions hearing. By way of background, this is a defamation case that started on December 17th of 2018, and a second amended complaint was filed on January 3rd of 2020. The case got reassigned to me in September of 2020. I entered an order denying various motions to dismiss on May 26th of 2021. A scheduling order was issued on July 28th of 2021 with basically discovery. The order required discovery to be completed in May, although there were some extensions, and Mr. Colborn's deposition, plaintiff's deposition, was yet to take place and was, I think, to be completed by the end of July. We have had a couple recent hearings on discovery motions, which the court resolved most recently on June 14th. The court granted a motion to compel and directed the parties to meet and confer on whether that the production in response to that motion to compel necessitated any changes to this existing schedule. The parties have since filed a status report indicating that no adjustments are necessary as a result of that. On June 24th, the defendants filed a motion to restrict a document. It is a confidential, it's the transcript of a deposition of a witness marked confidential, and some of it has been undesignated confidential and filed with the court, but apparently there's a portion of it that the counsel for the witness declined to consent to withdrawal of the confidentiality designation, so the defendants filed it under seal and along with a redacted version, consistent with the local rule, and filed the appropriate motion to restrict the document, although I think defendants do not maintain that it is properly designated as confidential. On June 24th, that same day, the defendants also filed a motion to allow an extended 14-hour deposition of the plaintiff. They argue that this is a multi-party lawsuit that's a very lengthy complaint has involved extensive discovery, and there are various, I think, 8 aspects of plaintiff's claims that they think they maintain they need to cover with the plaintiff during his deposition, and that 7 hours, which is the presumptive limit under Federal Civil Procedure 30D, is insufficient. On June 28th, the parties filed their joint status report indicating no adjustments to the schedule were necessary, and then on July 5th, plaintiff responded to the motion for an extended deposition, objecting to it, arguing that there's no cause for more than 7 hours and that 7 hours ought to be sufficient. Plaintiffs note that plaintiff is a fact witness who can only testify to the facts within his knowledge, and that many of the aspects of the claims that defendants claim they need to explore are really outside of his personal knowledge. They also point out that much of the other information is available in other documents. There was also an issue as to attorney-client privilege waiver, and the plaintiff concedes that in the response. So we're here today. So I know that depositions are upcoming. I want to make sure that we get discovery completed promptly. So I set this for a hearing on short notice to try to work through these things. Again, these are a lot of these are issues that I would expect counsel to be able to work out amongst themselves without bothering the court, but obviously that did not happen here. So let me take these one at a time. First, there is this issue with the motion to restrict the document, and let me start with defense counsel. I'm not sure who's taking the lead, but am I correct that this is a deposition of a third-party witness, and that witness's counsel designated this material confidential under the confidentiality and protective order, and that they withdrew most of it, but not all of it, and now so the defendants do not are filed it because they wanted to file it in support of the current motion, but the defendants actually do not believe that this material should be, confidential to the point that it would be required to be filed under seal. Is that correct?
Yes, Your Honor, that's correct.
And the portion that was, I reviewed the portion that was redacted, and then I reviewed the portion that was unredacted. It wasn't entirely clear to me what the portion redacted covered. Is it the portion that talks about the confidential mediation? Is that the part that has remained, or that the witness's lawyer seeks to have maintained confidential?
That was what I took away from it, yes, Your Honor.
And did you have any, is there any, well, let me turn to plaintiff's counsel. Mr. Burnett and Mr. Griesbach, what is plaintiff's position on the confidentiality of the portion that is redacted?
We take no position on that, Your Honor. We didn't participate in the redaction.
And Mr. Vick, what is the rationale that, if any, that was given for maintaining that portion redacted?
I don't recall a specific rationale, to be honest, Your Honor. Just we provided it. We let Ms. Schuler's attorney know which pages from the deposition we intended to include with our motion, and we asked him for his position regarding whether he was maintaining that any of them were confidential, and those were the ones that he identified that he was maintaining are confidential.
And who is the lawyer for the witness?
The attorney's name is, it's Nicholas Kurtz.
Your Honor, if I could interject here, I have been in touch with Mr. Kurtz because we're still trying to get some documents responsive to a subpoena we served on his client, Brenda Schuler, whose deposition transcript is at issue. I made sure he was aware of this motion, and I told him that given how you dealt with a similar motion the last time around, you might be asking him for a statement of good cause. This was last week, maybe several days ago anyway, and he indicated he understood that and was prepared to file something. I don't believe he has, however.
So it's hard for me to see what reason there would be to keep this portion restricted, filed under seal. But what I will do is I'm going to allow him 7 days from today's date, so until July 14th, to file, if he chooses, a brief explaining why these materials need to be maintained under seal on the court docket. If he doesn't file anything by July 14th, the motion to restrict will be denied and the documents will be unsealed. If he files something, I will take it under advisement and consider it. And if I need to if I need more briefing or more input from the parties, I'll docket something, but I suspect I'll be able to rule based on what he files. So that's how we'll deal with that issue. Any questions from any of the lawyers on that?
No, thank you, Your Honor.
None, Your Honor.
No, and I'm happy to let Mr. Kurtz know about the 7-day deadline.
Thank you. I will. Thanks for volunteering. I will include that in the minute order. Then the next issue is the motion for the double length deposition. And again, I'll start with defendant's counsel because it's your motion. You're the one seeking the 14 hours. My question is, why is it that you think 7 hours are insufficient? And in answering that, I realize that certainly Mr. Colborn is a central witness, one of the central witnesses in this case. But it strikes me that while this is a defamation case and maybe a little more high profile than many of the cases we have, any of the diversity cases we see, which really isn't that much different than any other tort claim diversity lawsuit. And so the presumption is 7 hours. I realize that there are multiple defendants here, but it seems to me the defendants are essentially aligned in terms of their arguments, their issues. And it also seems to me that in terms of defamation and intentional infliction of emotional distress, now those are two tort claims, but it's not all that uncommon for a diversity case that we see to have, or it's a tort claim to have multiple tort claims and multiple legal theories. And usually 7 hours is enough to cover those. A lot of the facts that the aspects of the plaintiff's claims that were identified in defendant's motion seem to be facts that are in defendant's possession or knowledge, much more so than the plaintiff. I think obviously the actual malice issue, which is at the forefront of these types of claims, something that plaintiff is likely not to have a whole lot of factual knowledge of. That's something that's going to be within the defendant's knowledge. Damages, certainly, I get that. But in mitigation, I agree that those are all things to explore. But again, those things happen in every tort case. And so defense counsel has to, is expected to be able to adequately investigate those things in 7 hours. Anyway, that's my long introduction to saying why is it, what makes this case so different from the standard one that you need more time, and why an additional 7 hours, which is like a lot. Go ahead.
Thank you, Your Honor. I appreciate the question, and I'll do my best to answer it. I think it's interesting that you brought up the idea that there's this presumptive 7 hour limit, and that's something that you anticipate that in your garden variety tort case should be sufficient. And in a simple, straightforward defamation case, I think it would be. In a simple, a sort of ordinary defamation case, it might involve an article that's, a couple pages long. There's a couple challenge statements that plaintiff has zeroed in on and is claiming are allegedly defamatory. That's sort of your typical defamation case. And in a case like that, it would probably take, if not 7 hours, still pretty close to the 7 hours to cover the standard lines of questioning. I'm getting a lot of static on my end, Your Honor. I don't know if that's just me or if that's everyone else.
If for the rest of the parties, it sounds like somebody's maybe walking outside in the wind. If you're not talking, if you can mute your phone, that would be great. Thank you. Please proceed.
Great. Yeah, I can hear much better now. So in that standard case, there's the standard lines of questioning: plaintiff's background, the underlying events leading up to the article at issue, the article itself, the handful of allegedly defamatory statements, actual malice, claim damages, mitigation of damages, the key issues related to certain defenses, the sort of things that Your Honor was talking about. And even in that sort of standard, simple, relatively straightforward defamation case, I can say from experience, you may not, if it doesn't go the full 7 hours, it's likely to go, 5 or 6 hours. I mean, we've had depositions in this case already of third parties that have gone close to the 7-hour limit. So that's just your sort of relatively simple, straightforward defamation case. However, this case is very different than that. This case is far more complex, and that's really why more time is needed. Now, it starts with the complaint here. The complaint here is 56 pages. It's got pages and pages of allegations about the substance of Making a Murderer itself being a 10-hour documentary series. Those allegations themselves, they relate to events that stretch back to 1985 and continue forward through, at least the trial of Stephen Avery and Brendan Dassey in 2007. Now, besides those allegations in the complaint itself, there's Exhibits A and B to the Second Amended Complaint, which contain lengthy compendiums of things about which plaintiff is complaining. To expand the world even farther out, you have Sergeant Colborn's interrogatory responses. We served interrogatory responses that, among other things, tried to get at the bottom of, okay, what are all your complaints? What is it that you're saying was done wrong? The interrogatory responses that we've received are about 70 pages. Netflix has gotten 15 pages more. So in contrast to your average garden variety defamation case where you might have, a couple of challenge statements, we're dealing with a much larger universe here. As Your Honor also indicated, Sergeant Colborn also has an intentional infliction of emotional defense claim. That means that, there'll be additional questions there above and beyond those having to do with defamation, addressing the elements and key issues and some of his claim damages that he's claiming under that claim. Now, we tried to streamline discovery considerably by serving some RFAs that I thought were pretty non-controversial, but they virtually all got denied. These were ones that are going to further require us to go into some detail and to, ask him, okay, why are you denying this? Why are you denying that Avery's defense attorneys made certain contentions at the trial? So that's going to take more time. And also, underlying all of this is Sergeant Colborn, he chose to bring a single lawsuit against 4 separate defendants, Netflix, Ms. Charee, Ms. Demos, and Chrome Media. He's seeking more than $10 million from each of them. So that means that each defendant here is facing considerable financial and economic risk. They're also facing, professional risk, reputational risk. I can tell you my clients, they take this lawsuit very seriously. He's made very serious allegations about the integrity of Making a Murderer and about their professional representations, in addition to bringing claims that have really put their personal financial situation on the line here. Now, under those circumstances, each defendant deserves the opportunity to ask Mr. Colborn the questions that are necessary to fully understand the basis for his lawsuit and to evaluate and continue developing the defenses to the lawsuit. The stakes are high, very high, and there's so much ground to cover. Now, Your Honor has said that you think, well, it seems like the defendant's interests are aligned here and there's things in common. That's true to a point, and undoubtedly we will be able to avoid certain duplication of questioning by nature of the fact that there are issues that overlap and that we have interests in, and we can sort of try and get things coordinated in advance to make that more streamlined. Because the last thing we want to do is duplicate the questioning, is just make it needlessly long. But there's other issues where the interests, can be different. They can have different points of emphasis, different areas that Netflix wants to cover that, for example, my clients might not, and vice versa. The question of actual malice is going to be different as between the defendants to a certain respect. There's allegations in the Second Amendment complaint about Ms. Charee's and Ms. Demos' knowledge about certain alleged information that are not made out to Netflix, so I would anticipate those would be ones that I would have to go into in more detail in terms of asking Mr. Colborn why he believes certain things that he has alleged in his complaint. And that Netflix may not. It's also worth remembering, originally in this lawsuit, this was before Your Honor came on the scene, there was one set of lawyers representing all defendants. A couple years ago, that changed, and the Ballard Bar firm still represents defendant Netflix, but my firm entered the picture, and we're representing Ms. Demos, Ms. Charee, and Chrome Media. So while there are some overlapping interests, these are distinct defendants. Mr. Colborn chose to sue all of us. He's chosen to sue not all of us, literally the attorneys, but the parties. He's chosen to bring a lengthy lawsuit against the 4 defendants, and they each have a right to ask him questions. Now, there's also things that have arisen in this litigation that give us reason to believe that deposing Mr. Colborn will present really somewhat unique challenges that are going to mean that his deposition is going to take longer than that of a typical defamation plaintiff. I would say first and foremost is the fact that he has indicated in discovery and in communications with various third parties that he has never even watched Making a Murderer. He's filed this lawsuit. We've been going on for years. There's been a just incredible amount of discovery and burden. But apparently Mr. Colborn has never watched the documentary about which he's complaining. That means when we're asking him questions...
Shouldn't that make the deposition shorter?
No. I think that's what Mr. Colborn stated in his opposition, but the contrary is actually true, because these are the allegations that he's making, that he has to stand behind, consistent with Rule 11, among other things. And that means that we're going to have to spend a certain amount of time...
His lawyers are the ones that drafted the complaint. He's a fact witness, and they may have all kinds of strategic reasons for alleging what they've alleged, and certainly it will be his and his lawyer's obligation to prove it. But I would be shocked if an individual defamation plaintiff has firsthand knowledge of all of the things that his lawyers have alleged in the complaint. It's not a
That's undoubtedly true, Your Honor. If this was a case where we were thought that he's going to have personal knowledge about everything in that 56-page complaint, candidly, I'd probably be asking for 28 or 35 hours, not 14. So I do think the fact that he doesn't know about certain issues will cut down things in certain aspects, but there's other issues where he's making allegations saying that is false, allegations where he has at least purported personal knowledge. And he's saying not only is it false, but the way that this is depicted in Making a Murderer is misleading. So that means we're going to have to orient him. We're going to have to spend a certain percentage of this deposition showing him the portions of Making a Murderer about which his complaint complains, for example. That's going to mean it takes more time to go into detail on those, to provide the context, to get him up to speed than we would face in a normal case in which the plaintiff at least, had watched the documentary before he filed suit. So that's an instance where I actually think that's going to end up lengthening things. Now, Mr. Colborn's complaint is also it's not just about certain statements or alleged implications, but also things like the music, the graphics. There's a list of numerous, what he calls omissions that he would have liked Making a Murderer to include. Those are going to take more time. There's also the fact that Mr. Colborn has complained in documents that we've seen in discovery and elsewhere about numerous statements that either appear or are alluded to in Making a Murderer, but that were first made by Mr. Avery's defense team, or that were first made by other members of the media or reporters or people looking into this issue back in 2006, 2007. You have John Farrick, a reporter who covered it in depth at the time and then subsequently wrote a book about it. So you've got a situation where Mr. Colborn is complaining about statements that get repeated. And sorry, I believe you were asking something.
But my point is, if that is all true, that's true. That's true regardless of whether he says it or not. I'm not sure what if somebody else, if a member of the defense team or if some other reporter reported on something and the documentary repeated that. That's a fact. It is what it is. Asking Mr. Colborn about it as a fact witness isn't going to make that fact more likely or less likely to be true. sort of irrelevant, and whether he knows that or doesn't know it, I'm not sure how that moves the ball forward in terms of the legal claims. So, like, I appreciate there are lots of issues, but it still seems to me that a lot of the stuff you're talking about is not something that the plaintiff, as a fact witness, is going to have any knowledge about, and you can ask him if he has any knowledge about it, and if he says, "Oh, I didn't know that," I'm not sure what more questioning one would do on it. But anyway, continue your argument. I apologize for interrupting.
No, it's a fair question, and I'll answer it, Your Honor. It goes to the issue of proximate causation of damages. Mr. Colborn has claimed that making a murderer defamed him, injured him, caused him all this damage. But when it's allegations that are first made by Mr. Avery's attorneys in connection with the criminal trial are then made in the media, often by many different members of the media, television, print, etc., books, and then they're made in Making a Murderer, and he's laying it all at the feet of the defendants in this lawsuit, it's important to ask him questions about the timeline, the sequence, his ideas for why these claimed damages, A, to the extent to which they really exist, and B, how is he claiming that the defendants who he is suing in this lawsuit have proximately caused them. So that's an example of a situation where these sort of layers, the historical layers that we're dealing with, add levels of complexity that will require additional questioning above and beyond your typical defamation suit. That ordinary case where I grant 7 hours should be sufficient. Now, so far what I've talked about is sort of the standard questions that we have to ask Mr. Colborn about. There's also some non-standard stuff that's come up. I mean, there's the connection between this lawsuit and Convicting a Murderer, the so-called counter-documentary that's designed to be a response to Making a Murderer. Its executive producer, Brenda Schuler, whom we talked about earlier with respect to the motion to restrict, it turns out she drafted portions of Mr. Colborn's complaint. She also served as a fact-checker for his attorney, Michael Griesbach's book, and she provided substantial input to Mr. Griesbach and Mr. Colborn for this lawsuit. She testified as to many documents and materials that Mr. Colborn handed over to her. We want to ask about those documents. We want to know what he gave her. We want to make sure we've gotten everything. We want to know what Mr. Colborn discussed with Ms. Schuler and Mr. Griesbach, because Ms. Schuler's presence there, even leaving aside Your Honor's ruling last week on the motion regarding Mr. Griesbach, we contend that there's been a waiver of privilege and that we're entitled to know all the substance of those conversations that went on. We also want to ask more about what transpired, how it is that Ms. Schuler learned about what happened at the court-ordered mediation before Magistrate Judge Duffin that was supposed to be confidential. She also, Ms. Schuler, testified that, convicting a murderer, it's going to make Stephen Avery look guilty as heck and humanize the hell out of Andrew Colborn. Well, Mr. Colborn's allegations in this lawsuit is that, making a murderer is biased. It's unfair to him. So we want to ask him a little bit about, what are the viewpoints that documentarians can have? What is fair, what is not fair, and we want to know about this exclusive agreement that he signed, apparently, with the Convicting a Murderer documentary filmmakers. That's going to go to issues like mitigation of damages. It's going to go because it turns out that maybe he's been restricted from speaking out publicly and stating his side of the story with regard to certain issues. We want to know about, to what extent, if any, this lawsuit has been connected with the efforts of the Convicting a Murderer producers to spark interest in their project, including finding a distributor for the documentary, marketing, publicizing, etc. And so these are other things that we'll want to go into. And that leads me to another issue that we're going to have to go into, which is discovery. Now, a simple defamation case, it's going to have pretty limited discovery. Often in defamation cases, one of the things that candidly I enjoy about handling these cases is they're not discovery heavy. They are more simple and straightforward and more often that way. This one, however, is not. Sergeant Colborn himself has produced thousands of pages of documents. In addition, thousands of texts, including about 4,000 with Brenda Schuler. We've had third parties, including Sergeant Colborn's former employer, the Manitowoc County Sheriff's Office, has produced tens of thousands of pages in response to various subpoenas. We've gotten very significant productions as well from Calumet County and from the Wisconsin DOJ. Now, my own clients, we've produced, I think, almost 50,000 pages to date. Between the two of them, my clients, Ms. Demos and Ms. Charee, they've spent about 300 hours of their own personal time responding to Mr. Colborn's 7 sets of requests for production. That includes, searching for responsive documents, reviewing documents. They both spent many, many dozens of hours duplicating certain footage that Mr. Colborn requested in discovery and then quality checking that we then provided. They sat for 7-hour depos each. Actually, Ms. Demos's deposition went more than 7 hours. I think it went about 7.5 hours. Now, I didn't object because she was sitting there. They were asking. This is discovery. Sometimes things take a little bit more time. So I didn't stand up after 7 hours and say, I object. I let it go on. I let it conclude until plaintiff indicated that they were done with the questioning. So now that's what happened with the 2 Netflix executives as well. They both sat for full-day depositions, as did Ms. Charee. There have been depositions of Eleanor Daly, who worked with Crow Media back in the day. And then just last week, there was a nearly full-day deposition of Mary Manhart, who's a third party who was one of the editors on Making a Murderer. Now, she's not even a party to this lawsuit, and plaintiff's counsel went almost, I think, probably about 6 hours on the clock with regard to Ms. Manhart. This is all to show that there's been incredible burden. I feel like we've been eminently reasonable on the defense side in terms of what we've allowed, what we've been willing to do. And under these circumstances, and given this great complexity of this case, and given all the issues that we have to cover and how much more there is than in your average garden variety defamation or even defamation plus i.e. intentional infliction of emotional distress claim, I don't think it's unreasonable to now ask Mr. Colborn to sit for 14 hours of deposition so that all of the defendants that he's chosen to sue get a fair opportunity to question him in this lawsuit that he's brought against all 4 of them for more than $10 million each, and that they are facing at extreme personal, professional, and financial peril. Thank you, Your Honor.
All right. Mr. Burnett?
Yes, Your Honor. Just a few thoughts. In listening to Mr. Vick's comments, I think there's a fundamental disagreement between the parties as to what the purpose of a deposition is. It sounds like, in Mr. Vick's mind, the purpose of Mr. Colborn's deposition is for Mr. Colborn to defend the lawsuit he has brought, to explain to the defendants each and every element of his case, each and every aspect of his complaint, and justify it. That's not the purpose of a deposition. The purpose of a deposition is for the defense to have adequate opportunity to question a witness about what he or she knows. Nothing more, nothing less. Now, what I heard was a long list of the various issues in this case that the defense intends to raise, and that's certainly their prerogative. But Mr. Colborn can't answer most of those questions. I heard a lot of things that left me a little puzzled. We heard about Ms. Schuler helping draft Mr. Griesbach's initial complaint in this case. Why that's a subject matter here in this case now when that's not the operative complaint? I don't know. I heard that somehow or other Mr. Colborn demands $10 million from each of the defendants. I don't know where that comes from. No one's ever asked me for a demand. I heard that the defendants are represented by separate counsel and therefore working separately and independently. I would point out that Mr. Friedman, their local counsel represents each of them. and they have been working hand in glove, which is, of course, their prerogative, and their interests are largely united in this case. I still don't have a good explanation, haven't heard a good explanation as to why 14 hours, which seems quite extravagant to me, is necessary to plumb all these depths. And I did offer a compromise. I understand this court is going to allow the defendants to question Mr. Colborn so as to discern what he knows about the various issues in this case. And after reasonable questioning, if they can't complete it in 7 hours, I told Mr. Vick that I would let it go further. But he and I are both at a disadvantage here of trying to anticipate what questions are going to be asked and what answers are going to be received. My dealings with Mr. Colborn have been rather straightforward. I don't think he's going to be an evasive witness. He certainly didn't appear that way in his trial testimony or in his deposition testimony. So my compromise to the defendants, which was unacceptable, was let's see where this goes, recognizing that Judge Ludwig is going to make sure that everybody has enough information from various witnesses so as to defend this case. I don't want to repeat what I've already said in briefing and in my June 6, 2022 email, where I essentially laid out our position on this. I just don't think that different rules should apply to different litigants. We have confined ourselves to 7 hours of questioning, with perhaps the one exception that Mr. Vick mentioned. I don't know how long Ms. Demo's deposition went because I wasn't at the entire thing. But it doesn't sound like it went much further than 7 hours. And of course, if that's the situation with Mr. Colborn, I would afford the same courtesy.
Thank you.
Your Honor, may I say a few words as well?
Sure.
So a couple things Mr. Burnett said that I just wanted to address. First, he said he didn't know where the claim for over $10 million had come from, and I will represent to you, and I'm happy to provide them, that came from Mr. Colburn's responses to interrogatories. He put that in writing. And with all due respect to Mr. Burnett, he has not been particularly involved in this case. He swoops in here and again for this deposition and one other in the case, and for the most part hasn't even attended the rest of them. And so to the extent he's confused about why some of these topics are relevant, I'm not surprised that he's confused. As to his point that he does not think Mr. Colborn would be evasive, I wanted to emphasize what Mr. Vick started to tell you about the requests for admissions that were served upon Mr. Colborn. His responses to them were extremely evasive, and I'll give you an example of how. There were very straightforward questions in those requests for admission to the effect of admit that Avery's defense team at trial contended that law enforcement planted evidence to frame him. There was a series of questions like that. Admit that it was Avery's defense at trial, that. Admit that it was Avery's contention at trial, that. And in connection with every single one of them, Mr. Colborn denied them on grounds that the definition of contend is to assert in a strong and definite way, and that because they didn't assert these defenses in a strong and definite way, they didn't contend them, and therefore he can't admit that these things that he's complaining about in his complaint against Netflix were first raised by Avery's defense at trial. So if we're quibbling over the definition of contend, I really struggle to see how Mr. Burnett can say his client is not going to be evasive at the definition, at the deposition. So just two more points briefly, Your Honor. I, too, am concerned that Mr. Colborn hasn't taken 10 hours over the course of 3 years to watch the very documentary that he sued over. And I completely agree with Mr. Vicks that that means this case will take more time because his counsel have conceded, as they must, that defamatory statements, alleged defamatory statements, have to be viewed in context. And in this case, context means within a 10-hour documentary. And so Mr. Colborn, whether he's done it himself or whether he's been led down the path by his counsel, has cherry-picked statements that in isolation he believes are misleading. But we're going to have to show him minutes, perhaps an hour or so, off and on, of the documentary itself. And then lastly, Your Honor, I take the point in Mr. Burnett's brief and points that you've raised today that we have a documentary, we have a trial transcript, we have deposition transcripts, and that those things should speak for themselves. But that is actually what we argued at the motion to dismiss stage. We said to the court, look at the trial transcripts, look at Making a Murderer itself, look at the third-party news reports that were out there. As a matter of law, you can assess these things. We don't need discovery. They speak for themselves. This case should be dismissed. And we lost that motion. And the reason we lost it, and I'll take the risk of quoting the court's order back to it, is because in docket 176, the court said, if the record at summary judgment establishes that defendants reporting on the Avery case was substantially true, then they will be entitled to summary judgment. But we were sent back to do discovery in this case to prove substantial truth, despite the fact that there is strong record and written evidence of many undisputed facts in this case. And so that's where we're at. That's what we're trying to do now, because we weren't able to do it on the transcripts alone, and that is going to take some time.
So on that last point, the transcripts, all of that stuff, those are factual issues, and I know there's case law that talks about in certain motion to dismiss contexts, the court can look beyond the pleadings to factual materials that are not disputed, contracts, things like that. But at the motion to dismiss stage, the parties were throwing, especially the defendants, were throwing a lot of factual material at the court. And I think at least in one of the early hearings, I suggested that that it really seemed like a motion for summary judgment to me, given all the materials that were put in play, or the defendants were trying to put in play. And if I treated it as a motion for summary judgment, I think I said this at a hearing. If I did that, if I went that far and denied it, I wouldn't be giving you a second shot at summary judgment later on after discovery. And we ended up proceeding with the motion to dismiss, and the court ruled as it ruled. But we don't need to go further down that road. But that's just a little, I guess, of my response to that argument. Let me say this. I do think that much of the stuff that defense counsel has identified today in terms of the subject matter for deposition is likely going to be outside of this plaintiff's factual knowledge. And so while it may seem like there's a lot of stuff there to cover, I think if you focus on this being a fact witness deposition, you will likely cover it a lot quicker than you think. Deposition should not be a place to argue with the opposing party about the merits of his claims, or to try to trick an individual plaintiff into making legal admissions that you try to use on summary judgment. This really should be a factual deposition. The fact that there are multiple defendants here, I'm not terribly persuaded by that. The fact that this is a significant amount of money, I certainly understand from the individual defendant's perspective, it's a lot of money. That being said, when I was in private practice, I worked on huge antitrust conspiracy cases where billions of dollars were at stake and with hundreds of transactions at issue, and still, corporate CEOs, corporate other executives would sit for 8 hours, and that was it. So the size of this case, it may seem, and I'm sure it seems significant it is significant to the parties, but in the overall scheme of things, it's not that massive a case, really. On the other hand, I will say that the complaint is lengthy and does identify a significant number, the exhibits of potential defamatory statements, which does make it hard it made it hard when I was working on the motion to dismiss to get my hands around what exactly was being alleged. And defendants have every right to go through those things and to try to identify those. To the extent and the idea that the plaintiff has not actually watched the entire documentary, then there are 2 series actually now at issue in the amended complaint. That I do think some of the allegations are factual allegations that may require setting context and asking about. I accept defense counsel's position on that. I think that's probably right. The question is how much of that is going to be required and how much of it is going to be fruitful. I also have questions in terms of whether depositions are the best form of discovery to obtain some of this information. Defense counsel have indicated that there are some inappropriate responses to requests for admission, that if the request for admission had been answered correctly, they could save some time. That's a good point. There are motions that can be brought with respect to requests for admit that are not that should have been admitted that are not properly admitted, and I would certainly consider that, and I'd encourage the parties to try to work through those issues rather than bringing them to me. But if there is a request to admit that is foolishly or frivolously denied, I won't look kindly on that. And so and some of that's already been suggested. I don't know the full context that was beyond what was just presented in the hearing, but it doesn't sound pretty, and it doesn't sound professional. With all that being said, what I'm going to do is I'm going to deny the motion, but without prejudice. I want the parties to act professionally to get this deposition done in an efficient way. And if it's going to run over one day into 2 in order to get the questioning done, so be it. And I will hold Mr. Burnett to his word that if the questions are asked in good faith and the testimony continues in good faith and it requires more time, he'll give them more time. But it's a hard thing to rule on in advance because I don't know what the questions will be, and we don't know how responsive the plaintiff will be, the witness will be. Let me also make clear that to the extent that, and I don't want to accuse anybody of anything going in, but I was a litigator for 22 years, and I've had my share of witnesses where there was a time limit on a dep and the witness starts running the clock out. I won't countenance that either. So I will deny this motion without prejudice, but I will expect the plaintiffs or the defendants to ask reasonable questions, to move through as quickly as they can. And if 7 hours turns out not to be enough time to do all that, I expect plaintiff's counsel to allow additional time. You should probably reserve 2 days for this deposition just in case. But I'm not going to rule at this point. I don't think I have a record sufficient for me to conclude that this will necessarily take more than 7 hours. If it does, again, plaintiff's counsel, you should let this deposition continue until it's done. And I'll leave it at that. If there becomes a dispute, during the deposition, we can take it up. Remind me, when is this deposition scheduled for?
June 21st or July 21st, and everyone has reserved July 22nd.
Yes. I will be in the office on the 22nd, as well as on the 21st. My afternoon of the 21st is wide open. If you want, I guess what I'd ask is if I will be available on the afternoon of the 21st and on the 22nd if issues come up that you need me to address. I really hope that doesn't happen, but I will let you know that those times are available on my calendar. Again, you guys are all professional, experienced counsel, and I appreciate that there are hard feelings on both sides of this case. The plaintiff is not happy with his portrayal in this documentary. The defendants are not happy that they got sued for defamation, and greatly are concerned about the damages that apparently have been demanded in discovery, even if counsel wasn't aware of that. So I get all of that, but you guys are experienced. You should be able to work together to resolve this without further intervention of the court. But if you can't, I will be around on the afternoon of July 21st to address any issues we need to address. But again, let me strongly discourage that. I certainly don't want to invite that. Any questions?
None from the plaintiff, Your Honor.
No, Your Honor.
None. No, Your Honor.
All right. We will draft a minute order with all of this, also giving Schuler's lawyer 7 days to respond on the sealing issue. But again, let me encourage you to work together to try to get this resolved. Because let's get discovery resolved, let's get dispositive motions filed, and let's try to get this case resolved. All right. Thank you for your time this afternoon.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.